Hi, this is Terry Babcock with Real Estate Consulting, LLC, located here in sunny South Florida. This is the second in my video series about celebrating the Florida Land Trust Act. This is the bill analysis and fiscal impact statement from the Florida Senate. But before I get into this, let me cover my assets and read the following disclaimer. By watching this video, you agree, acknowledge, and understand that this video and all the opinions expressed herein by its makers are not to be considered professional advice. Nothing contained herein should be construed as legal and or accounting advice, and it is strongly advised and encouraged that you consult your own legal and accounting professional before utilizing any of this information. You are solely responsible for the use of these ideas, the concepts, opinions, and content contained herein, and agree to hold Real Estate Consulting, LLC, and all its members, successors, assigns, and affiliates completely harmless in any event or claim. Again, I am not an attorney, nor should any advice I might offer be construed as legal advice. The assistance of competent legal counsel is always recommended. With that being said, let's get to our document here. Okay, let's scroll down to where I've highlighted some issues we're going to go over. Summary: SB 1172 revises the laws relating to land trusts. In general, a land trust is a written instrument which title to real property is vested in a trustee who has the authority to manage or dispose of the property. More specifically, the bill clarifies the distinction between a land trust governed by Statute 689.071 and other trusts governed by Florida Trust Code. Defines a land trust based on the functional scope of the land trustee's duties, although the power to manage or dispose of property remains an essential element of a Florida land trust. It relocates provisions of Statute 689.071 to a newly created section, Statute 689.073. These provisions generally state that purchasers and others can rely on a land trustee's authority over property as described in a recorded instrument. These provisions will remain equally applicable to any recorded instrument created before or after the effective date of the bill, which conveys title to property and the power to manage or dispose of the property. It codifies a number of land trust practices and principles commonly used in Florida and Illinois, which are derived from judicial precedents or treatises on land trusts. The bill creates Section 689.073 Florida statutes. The bill substantially amends Section 689.071, 689.073, and 736.0102 of the Florida statutes. The land trust is a unique creature of Illinois law, where real estate is conveyed to a trustee under an arrangement, reserving to the beneficiaries the full management and control of the property. Under a land trust, the trustee executes deeds, mortgages, or otherwise deals with the property at written direction of the beneficiaries. The beneficiary collects rent, improve and operate the property, and exercise all rights of ownership other than holding or dealing with the legal title. While legal title to the real estate is held by the trustee, the beneficiaries retain the power of direction to deal with the title, to manage and control the property, to receive proceeds from sales or mortgages, and all rentals and avails of the property. Land trusts were initially developed in Illinois. The use of land trusts in Florida was validated by the enactment of Statute 689.071, the Florida Land Trust Act in 1963, which is why we are celebrating the 50th anniversary in 2013. Let me scroll down some more. You can read that on your own. The primary purpose of this bill is to provide greater clarity in the manner that the Florida Land Trust Act and the Florida Trust Code are intended to relate to each other by specifying a comprehensive statutory definition of land trust. The effect of the proposed changes: the bill clarifies the distinction between a land trust governed by Statute 689.071 and other express trusts governed by the Florida Trust Code, but preserves the title protection benefits of the existing statute for any conveyance to trustee containing deed powers. To do so, the bill, you can read the following of that. Purchaser protection provision transferred to section 689.073. The bill transfers and amends the purchaser protection provision in statute 689.071 and newly creates 689.073. The existing statute are transferred to 689.073 are intended to have exactly the same legal effect. The provisions protect a purchaser who buys or leases land from a trustee if the trustee acquired the land by a recorded deed or other instrument that granted certain deed powers to the trustee. If those deed powers are recorded, then the statute protects the purchaser by confirming that. The trustee invested with title to the property and is fully able to transfer the title to the purchaser. The purchaser is protected from title assaults by the beneficiaries of the trust. The beneficiaries need not be disclosed. The trust document need not be disclosed, and the purchaser may safely deal with the trustee without inquiring whether the trustee has authority to deal with the land. And moving on. Statute of uses and doctrine of merger revisions to statute 689.071. Basically, I'll read the highlights. The new subsection 609.071 overrides the doctrine of merger with respect to a land trust. So a land trust will not be extinguished if the trustee is the sole beneficiary. This simply states that you can be the sole beneficiary of your land trust and the trustee of the same land trust. The personal property option. This is a change to the law where currently 689.071 provides that the recorded instrument may define and declare the interests of land trust beneficiaries as personal property under Florida law. The bill clarifies that this designation of personal property must be made in the recorded instrument or the trust agreement, or it will be considered real property. Subsection 689.071 is modified to allow the optional personal property declaration to be made on the recorded instrument or in the trust agreement. So this is simply stating that you must choose in your paperwork, in your trust agreement, that you want your beneficial interest to be considered personal property. If you don't state that in your agreement, it will default and be considered real property. The beneficiary provisions. The bill adds statute 689.071 as a statutory endorsement of flexible beneficial ownership techniques described in the Cano treaties. The purpose of including these provisions directly in the Florida Land Trust Act is to increase public awareness that such techniques are available without making reference to the treaties, thereby promoting the usage of land trust in Florida generally, which is what I'm trying to help do. Uniform Commercial Code, not really concerned about that. Vacation timeshare, not concerned about that. I believe there's a little more highlight stuff. Notice to trustee provisions. This bill adds a new section 689.071 to assure that right parties receive any third-party notices concerning property held in a land trust by requiring that notice to a land trustee include certain identifying information if it appears in the recorded instrument. Because there was some issue of, trustee would get a legal notice and not know which actual property that they were talking about. I think that's about it. Now, if you're interested in the Florida Land Trust, and I certainly hope you are, Mark Warda, the authority on the Florida Land Trust, he's the author of Land Trust in Florida, and he's on the committee that wrote the new statutes. He's having a seminar in October. If you go to YouTube and type in Florida Land Trust in your search engine, you'll come up with Mark, his he's the first two videos you'll see. Go ahead and watch those videos, and let's go to his website over here. This is his website, floridalandtrust.com, and let's scroll down here. You can check out his site when you get to it. Right now I just want to show you his brochure for his seminar. He's having it in Tampa, Florida, at the Ramada West Shore Hotel, which I believe is at the airport, if I'm not mistaken. Let's click here on this flyer. There we go. Land trusts and much more, personal property trusts, LLCs, Roth IRAs, increasing your profits and more. Learn how land trusts can give liability protection, structure short sale purchases, protect people in foreclosure, avoid deficiency judgments, how to keep your name off your LLC, and much more. It's presented by Mark Abuarda and Jack Shea, an author and investor. For you realtors and attorneys, it's 8 hours of continuing education for realtors, attorneys, and CPAs. It includes his land trust book with the Form CD, and it includes the 2013 Landlord LLC law changes. And it's all for a low price of $175. I mean, the book with the CD form alone is $50. So, I mean, it's a great deal. So give Mark a call and book your ticket, and I'll see you at the event, October 12th, Tampa, Florida. Thanks for watching. Have a great day.